169. 169/1 YB 21 and 22nd ed. I. 466 to 468, noticed in North America Rev. CXVII. For 21, N. So Britain, 26b, CIL Puis Avertir la Perte. This is not Trover. The declaration in Detinu per Inventionem was called Un Newfound Halliday, in YB 33 Hen. 6, 26, 27, CF 7 Hen. 6, 22, PL3, Isaac vs. Clark, IRAL, R. 126, 128. 169/2 YB 2 ed. 4. 4, 5, PL9, 21 Hen. 7, 39, PL49, Bro, Trespass, PL. 216, 295. 169/3 2 WMS Sond. 47, N. 1. See above, page 167. 170. 170/1 Notes to Saunders, Wilbraham vs. Snow, Note, H. 170/2 YB 11 Hen. 4, 23, 24. See, further, YB 8 ed. 4. 6, PL5, 9 ed. 4. 34, PL9, 3 Hen. 7, 4, PL16, 20 Hen. 7. 1, PL1, 21 Hen. 7, 14b, PL23, 13 Company. Republic 69, 1 Roll. ABR, 4, I, PL. I, F, N, B 86, N, Supra, page 167. 170/3 Fitz. ABR, bar, PL 130, YB 9 ed. 4. 34, PL 9, 12 AM. Law Rev 694. 171. 171/12 Steph. Com, 6th edition. 83, Cited Dicey, Parties, 353, 2 BL Com 453, 2 Kent, 585. As the Bailey recovered the whole value of the goods, the old reason, that he was answerable over, has in some cases become a new rule, seemingly based on a misunderstanding. That the Bailey is a trustee for the bailor as to the excess over his own damage. Cf. Lyle vs. Barker, 5 Bin. 457, 460, 7 Cowan, 68 L, N, White vs. Webb, 15 Con 302, 305, in the order cited. Thence the new rule has been extended to insurance recovered by a Bailey. 1 Hall, N, Y 84, 91, 3 Kent's Com, 12th edition, 371, 376, N. 1, A, dot. In this form it ceases to be a reason for allowing the action. 171/2 YB 48 ed. 3. 20, PL8, Bro, Trespass, PL67. CF1 Britain, Niche. Edition, 67, 26b, YB 6 Hen. 6-1. 12, PL9, 12 ed. 4. 13, PL9, 12 AM. Law Rev 694. 172. 172/1 YB 22 ed. 4. 5, PL 16. 172/22 Rawl, ABR, 569, Trespass, 5. CF YB 20 Hen. 7, 5, PL 15, 21 Hen. 7, 39, PL 49, Clayton, 135, PL 243, 2 WMS Sond. 47E, 3D edition. 172/3 Bro, Trespass, PL, 67 in MARG, CF ed. Liap. 131, Cited Supra, page 166, N. 172/4 in one instance, where, against the opinion of Bryan, the bailor was allowed to sue for damage to the chattel by a stranger. The action seems to have been case YB 12 ed. 4. 13, PL 9, cf. The margin of the report. 173. 173 to 1 Gordon vs. Harper, 7 T. R. 9, Lord vs. Price, L. IL 9x54, Mugridge vs. Eveleth, 9 Met. 233, cf. Clayton, 135, PL 243. 173 to 2 Nichols vs. Bastard, 2 C. M. and R. 659, 660, Manders vs. Williams, for exchange. 339, 343, 344, Morgan vs. Ide, 8 Cush. 420, Strong vs. Adams, 30 Vanuatu Vatu, 221, 223, Little vs. Fosseft, 34 Me. 545. 173/32 Camp. 464, cf. Mears vs. London and Southwestern Railway Company, 11 CB NS 849, 854. 173 to 4 Addison, Torts, 4th edition, 364. 174. 174 to 1 WMS, Purse Prop, 26, 5th edition, 27, 7th edition. 174/2 Booth vs. Wilson, IB, and Alderman 59, YB 48 ed. 3. 20, PL 8, 11 Hen. 4, 17, PL 39, 11 Hen. 4, 23, 24, PL 46, Trey. OUD Prompter, 21 Hen. 7, 14B, PL 23, Godbolt, 173, PL. 239, Sutton vs. Buck, 2 Taunt. 302, 309, Burton vs. Hughes, 2 Bing. 173, Nichols vs. Bastard, 2 C. M. and R. 659, 660, Manders vs. Williams, for exchange 339, 343, 344, 2 WMS Sond, note to Wilbraham vs. Snow, 2 Kent, 585, 568, 574, Moran vs. Portland S. P. Company, 35 Me. 55, C. Further, Lecture 6. Ad Fin. 175. 175/1 cf. Lord vs. Price, LR 9x54, 56, Supra, page 172. 175/2 Supra, page 167. 175/3 Lib X C 13, CFI, C 8. 175/4 is Carem Commodatum Accipit, ad ipsum restituendum tenetur, vel aegis pretium, si forte incendio, ruins, naufragio, et latronum, vel hostium incursu, consumpta furit vel deperdita, substracts, vel oblata. Fall, 99a, b. This has been thought a corrupt text, Güterbach, Bracton, by Cox, page 175, 2 Twiss, Bract. Int 28, but agrees with Glanville, Supra, and with Fleta, L. 2. C. 56, section 5. 175/5 Bract, folios 62b, C. 28, section 2, Fleta, L. 2. E. 59, section 4, folios 128. Cf. Just. Inst 3. 24, section 5, IB 15, section 2. 176. 176/1 YB 8 ed. 2. 275, Fitz. Detinue, PL 59. 176/22 Lord Rame. 909. 176/3 YB 13 ed. 4. 9, PL 5. See Lecture 6. 176/429 As. 163, PL 28. 176/5 cf. Ratcliffe vs. Davis, Yelv. 178, Crow. Jack. 244, Noy, 137, 1 Bolster. 29. 176/6 YB 33 Hen. 6, 1, PL3. This case is cited and largely relied on in Woodlife's case, Infra, Southcott vs. Bennett, Infra, Pickering vs. Barclay, Style, 132, 24 Car. I. Covenant on a Charter Party, and Morse vs. Slew, Infra, in short, in all the leading cases on bailment. 177. 177/1 cf Abbreviatio Pleitorum, page 343, Kernel 2, Rot. 87, 17 ed. 2. 178. 178/1 YB 9 ed. 4. 34, PL 9, 2 ed. 4. 15, PL 7. It is proper to add, that in the latter case Littleton does not seem to distinguish between servants and bailies. 178/2 YB 9 ed. 4, 40, PL 22. So Bryan, in 20 ed. 4. 11, PL 10, ad fin. 178/3 YB 10 Hen. 7, 25, 26, PL 3. 178/4 CFL, Bave. 15. 5, YB 33 Hen. 6, 1, PL 3. 178/5 YB 6 Hen. 7, 12, PL 9, Bro, Detenu, PL 37, 10 Hen. 6, 21, PL 69. 178/6 YB 3 Hen. 7, 4, PL 16. CF 10 Hen. 6, 21, PL 69. 178/7 YB 11 Hen. 4, 23, 24, 6 Hen. 7, 12, PL 9. 178/8 Crow. Elise. 815, 4 Company. Republic 83B, Company. Lit. 89, 2 by. Com 452. 180. 180/1 Seville, 133, 134. Cf. Bro, Action sur le case, PL 103, Dyer, 161a, b. 180 of 2 Nugent vs. Smith, 1 CPD, 19, Brett, J. At page 28. 180 of 3 Nugent vs. Smith, 1 CPD 423, Cockburn, C. J. At page 428. 181. 181/1 more, 462, Owen, 57. 181/2 Dial. 2, ch 38, AD 1530. 182. 182/1 Keelway, 160, PL 2, 2 Hen. 8, CFIB 77B, 21 Hen. 7. 182/2 YB 33 Hen. 6, 1, PL 3. 182/3 4 Company. Republic 83B, Crow. Elise. 815. 183. 183/1 Keelway, 160, PL 2. 183/2 YB 19 Hen. 6, 49, ad fin. Cf. Mulgrave vs. Ogden, Crow. Elise. 219, SC, Owen, 141, 1 Leon. 224, with Isaac vs. Clark, 2 Bolster. 306, at page 312, Koch, J. 183/3 see Lecture 7. 184. 184/1 Patun, J. In YB 19 Hen. 649. See, also, Rogers vs. Head, Crow. Jack. 262, Rich vs. Neeland, Crow. Jack. 330, which will be mentioned again. An innkeeper must be a common innkeeper, YB11 Hen. 445. See further, 3BL Com. 165, where the transition from status to contract will be found to have taken place. 184/2FNB 94D, Infra, page 203. 184/3YB7 Hen. 414, 12 ed. 4. 13, PL9, 10, Dyer, 22b. 184/ for the process may be traced by reading, in the following order, YB2 Hen. 7, 11, Keelway, 77b, Ad Fin. 21 Hen. 7, IB 160, PL2, 2 Hen. 8, Drake vs. Royman, Seville, 133, 134, 36 Elise. Mosley vs. Fawcett, Moore, 543, 40 Elise. 1 roll. ABR 4, F, PL5, Rich vs. Neeland, Crow. Jack. 330, 11 Jack. I. 185. 185/1 Crow. Jack. 262, 8 Jack. I. Compare Maynard's argument in Williams vs. Hyde, Palmer, 548, Simons vs. Dark Knoll, IB 523, and other cases below, 1 roll. ABR 4, F, PL3. Mosley v. Fawcett, Moore, 543, 40 Elise, an obscurely reported case, seems to have been assumpted against an agister, for a horse stolen while in his charge, and asserts obiter that, without such special assumpsit the action does not lie. This must have reference to the form of the action, as the judges who decided Southcote's case took part in the decision. See, further, Evans vs. Yeoman, Clayton, 33. 186. 186/1 C. Simons vs. Dark Knoll, and the second count in Morse vs. Slough Infra. The latter case shows the averment of negligence to have been mere form. Cf. Isoc. 18, top. 187. 187/1 Supra, page 179. 187/2 Boson vs. Sanford, Shower, 101, Coggs vs. Bernard, Infra. 187/3 Simons vs. Dark Knoll, Infra. 188. 188/1 Reg Brev. 92b, 95a, 98a, 100b, 104a, CFYB 19 ed. 2. 624, 30 ed. 3. 25, 26, 2 Hen. 4, 18, PL6, 22 Hen. 6, 21, PL 38, 32 and 33 ed. I, int, 33, Brunner, Schwergericht, 177, ID Französisch, Inhaberpapier, 9, N, 1. 188/212 Company. Republic 64. 188/3C, besides the following cases, the declaration in Chamberlain vs. Cook, 2 Ventris, 75, 1 W and M, and note especially the variations of statement in Morse vs. Slough, set forth below, in the text. 189. 189/1 Hobart, 17, Crow. Jack. 330. See also George vs. Wyburn, 1 roll. ABR, 6, PL4, AD 1638. 190. 190/1 The use which has been made of this case in later times shows the extreme difficulty in distinguishing between principles of substantive law and rules relating only to procedure, in the older books. 190/2 YB 22 Hen. 6, 21, PL 38. Supra, page 188, n. 1. 191. 191/1 Palmer, 523. 191/2 Palmer, 548. 191/3 Elaine, 93. 191/41 Sid. 36. 192. 192/11 Sid. 244, cf. Dalston vs. Jansen, 1 Lord Rame. 58. 192/22 Keb. 866, 3 ID 72, 112, 135, 2 Leviticus 69, Ivent. 190, 238, 1 Mod. 85. Sir T. Rame. 220. 193. 193/12 Keb. 866, C3 Keb. 74, 1 Mod. 85, Sir T. Rame. 220. 193/22 Keb. 72. 193/3 YB 33 Hen. 6, 1, Supra, page 177. 193/43 Keeble, 73. This is the main point mentioned by Sir T. Raymond and Levins. 193/5 cf 1 Mod. 85. 194. 194/11 Ventris, 238, citing Southcote's case in the margin. Cf 3 Keeble, 135. 194/2 Elaine, 93, Supra, page 191. 194/3 C also 1 Hale, PC 512, 513. 195. 195/1 King vs. Viscount Hertford, 2 Shower, 172, PL 164, cf. Woodlife's case, Supra. 195/2 Boson vs. Sanford, 1 Shower, 101, 2 W and M. See above, pages 183,185, below, page 197. Modern illustrations of the doctrine will be found in Fleming vs. Manchester, Sheffield, and Lincolnshire Railway Company, for QBD. 81, and cases cited. In Borman vs. Brown, 3Q.B.511, 526, the reader the primitive assumpsit, which was the inducement to a declaration in tort, interpreted as meaning contract in the modern sense. It will be seen directly that Lord Holt took a different view. Note the mode of dealing with the Marshall's case, 33 Hen, 6. 1, in Elaine, 27. 196. 196/1 C. Lovett vs. Hobbs, 2 Shower, 127, 32 Carr. 2, Chamberlain vs. Cook, 2 Ventris, 75, 1 W. and M. Boson vs. Sanford, 1 Shower, 101, citing Southcote's case, 2 W and M. Upshare vs. AD, 1 Comins, 25, 8 W, 3. Middleton vs. Fowler, ISOC. 288, 10 W, 3. 196/212 Mod. 472. 196/3 Lord Rame. 909. 197. 197/1 Poutwary vs. Walton, 1 Roll. ABR, 10, PL 5, 39 Elise. CF Keelway, 160. 197/22 Lord Rame. 919, see Lecture 7. How little Lord Holt meant to adopt the modern view, that delivery, being a detriment to the owner, was a consideration, may be further seen by examining the cases put and agreed to by him from the year books. 199. 199/1 Kent, 598, 1 CPD. 429. 199/2 Palmer, 523. C2 Kielway, 77b, and 160, PL2, where the encroachment of case on détenu, and the corresponding confusion in principle, may be pretty clearly seen taking place. But see page 175, supra. 200. 200 to 1-2 Kent, 597. Forward versus Pittard, 1 Tr. 27. 200/2 CFYB 7 Hen. 4, 14, 2 Hen. 7, 11, Kielway, 77b, 160, PL2, and other cases already cited. 200/3 YB 41 ed. 3. 3, PL8. 200/4 YB 33 Hen. E. 1, PL3. 200/5 Reg Brev 107a, 108a, 110a, b. Entries cited 1 Tr. 29. 200/6 see above, pages 167, 175 each seek, 12 am. Law 692, 693, YB 42 ed. 3. 11, PL 13, 42 as, PL 17. 201. 201 to 11 Wilson, 282, CF 2 Kent, 12th edition, 596, N, 1, B. 201/2 YB 33 Hen. 6, 1, PL 3. 202. 202/1 Mouse's case, 12 Company. Republic 63. 202 to 2 Bird vs. Astcock, 2 Bolstra. 280, CF Dyer, 33A, PL 10, Keithley's case, 10 Company. Republic 139b, 140. 202/3 YB 40 ed. 3. 5, 6, PL 11, see also Willems vs. Hyde, Palmer, 548, Shep. Touched. 173. 203. 203 to 1 C Safe Delcausic Company of Pittsburgh vs. Pollock, 85 Penn 391. 203/2 Patun, J, in YB 21 Hen. 6, 55, Kielway, 50A, PL 4, Hardres, 163. 203 of 3 Lane vs. Cotton, 1 Lord Rame. 646, 654, 1 Sock. 18, 12 Mod. 484. 204. 204/1 Forward vs. Pittard, 1 Tr. 27, 83. 205. 205/1 Printing and Numerical Registering Company v. Sampson, LR 19 EQ, 462, 465. 207. 207/1 Possession, Section 6, ENGTR, pages 27, 28. 207/2 RD, Besitzes, 487. 208. 208/1 RD. Besitzes, 490, 491. 208 of 2 Bruns, RD, Besitzes, 415, Winscheid, Pand. Section 148, N. 6. Further Hegelian discourse may be found in Dr. J. Hutchison Sterling's lectures on the philosophy of law. 208/3 Institutionen, sections 224, 226. Winscheid, Pand. Section 148, N. 6. 208/4 Winscheid, Pand. Section 148, N. 6. 208/5 Besitzklagen, 276, 279. 209. 209 of 1 Bruns, R.D., Besitzes, 499. 209/2 Bruns, R.D., Besitzes, Section 2, pages 5 each seek, Pukta, Besitz, in Weisky, Rechtslex. Winscheid, Pand. Section 154, pages 461 ed. 4th edition. 209/3d, February 3, 41, section 20, 13.6.8 and 9. CFD, January 9, 41, section 5. 210. 210/1 but CI hearing, Geist D, Rom R, section 62, French TR, 4. Page 51. 210-2 Huesler thinks this merely a result of the English formalism and narrowness in their interpretation of the word soa in the writ, Discivit de Tumento soa. Goura, 429-432. But there was no such narrowness in dealing with cat alla sua in trespass. See below, page 242. 210/3c, further, Bracton, folios 413, YB 6 hen. 7, 9, PL 4. 211. 211-1 infra, page 243. 211/2 RD, Besitzes, 494. 212. 212 of 1 Rogers v. Spence, 13 and W 579, 581. 212/2 Webb vs. Fox, 7 R 391, 397. 212/3 Fennings vs. Lord Grenville, 1 Taunt. 241, Littledale vs. Scaife, IB 243, N. CF Hogarth vs. Jackson, M. and M. 58, Skinner vs. Chapman, IB 59, N. 212/4 Swift v. Gifford, 2 Lowell, 110. 212/5 1 Taunt. 248. 213. 213/1 CF Wake, Evolution of Morality, Part 1, ch 4, pages 296 each seek. 215. 215 of 1 Asher vs. Whitlock, LR 1Q.B.1. 215/2 People vs. Shearer, 30 calories, 645. 217. 217/1 2 Kent's Com. 349, citing Pearson vs. Post, 3 Canes, N. Y. 175, Buster vs. Newkirk, 20 Johnson, N. Y. 75. 217/2 Young vs. Hickens, 6Q.B.606. 217/3 2 Kent's Com 349, N. D. 218. 218/1 INST2. 1, Section 13. 218/2 Swift vs. Gifford, 2 Lowell, 110. 218/3 Savigny, R. D. Besitzes, Section 21. 218/4 2. 9, Section 4, 3. 29, Section 2. Animus Domini will be used here as shortly indicating the general nature of the intent required even by those who deny the fitness of the expression, and especially because Savigny's opinion is that which has been adopted by English writers. 219. 219 of 1 CF Bruns, R. D. Besitzes, 413, and IB 469, 474, 493, 494, 505, Winscheid, Pand. Section 149, N. 5, page 447, 4th edition. Pucta, INST Section 226. 219/2 Supra, page 207, 2 Pucta, INST Section 226, 5th edition, pages 545, 546. 221. 221/115 Jur. 1079, 21 L, J, Q.B.75, 7 ENGL, and EQ, 424. 222. 222/111 Allen, 548. 223. 223/1 Kincaid vs. Eaton, 98 Massachusetts 139. 223/2 Barker vs. Bates, 13 pick. 255, 257, 261, Proctor vs. Adams, 113 Massachusetts 376, 377, 1 BL Com. 297, Charse. Edition, N. 14. Cf. Blades vs. Hicks, 13 CB-NS 844, 847, 848, 850, 851, 11 HL.C. 621, Smith vs. Smith, Strange, 955. 223/3 Reg v. Roe, Bell, CC 93. 224. 224/1C, As to Treasure Hidden in Another's Land, D. 41. 244, PR, D. 10, 4. 15. Note the different opinions in D. 41.2. 3, Section 3. 224/23 INST 107, 1 Hale, PC 504, 505, 2 Bishop, CRM Law, Sections 834, 860, 6th edition. 224/3 Reg v. Middleton, LR2 CC 38, 55. CF Halliday vs. Hallgate, LR3 X299, 302. 224/4 CF YB 8 ed. 2. 275, Fitz. ABR, Detinu, PH 59, YB 13 ed. 4. 9, PL5, Keelway, 160, PL2, Mary vs. Green, 7M, and W, 623, 630. It may not be necessary to go quite so far, however, and these cases are not relied on as establishing the theory. For wrong explanations, see 2 East, PC 696. 225. 225/1 Durfee vs. Jones, 11 R. I. 588. 225/2 Reg v. Roe, Bell, CC. 93, stated above. 225/3 8 VS. 405, 7M and W, 623, Stephen, CRM Law, Art. 281, IL, 4, page 197. He says, because, the owner of the safe, cannot be presumed to intend to act as the owner of it when he discovers it, a reason drawn from Savigny, but not fitted to the English law, as has been shown. 226. 226/1 YB 13 ed. 4. 9, 10, PL5. 21 Hen. 7, 14, PL21. CF3 Hen. 7, 12, PL9, Steph. CRM Law, Art. 297, and App, Note 17. 226/2 Steph. Cottret. Law, Art. 297, and App, Note 17. Page 882. It may be doubted whether the old law would have sanctioned the rule in this form. F. N. B. 91E, YB 2 ed. 4. 15, PL 7. 226/3 YB 21 Hen. 7, 14, PL 21, 13 Company. Republic 69. 227. 227/1 They have been said to be a part of the family pro-hack vice. Southgate vs. Stanley, 1H, and N 247, 250. CFYB 2 Hen. 4, 18, PL 6. 227/2 more, 248, PL 392, SC, Owen, 52, FN, B, 91E, 2B1. Com 396, 1H, BL 81, 84, 1 Chitty, PL 170, 1st edition. Dicey, Parties, 358, 9 Massachusetts 104, 7 Cowan, 294, 3 S and R, 20, 13 Iredell, 18, 6 Barb. 362, and cases cited. Some of the American cases have been denied, on the ground that the custodian was not a servant. Cf. Holliday v. Hicks, Crow. Elise. 638, 661, 746, Drope v. Theyar, Popham, 178, 179. 228. 228-1 Bracton, Folios 6a, Section 3, 12a, 17a, Cap v. Ad Fin, 25a, b, etc., Puckborough, INST Section 228. 228/2c also 7 a.m. Law Rev 62 Eg Seek, 10 a.m. Law Rev 431, 2 Kent, Com, 12th edition, 260, n. 1. 228/31 Com 427. Cf. Preface to Paley on Agency. Factors are always called servants in the old books, see, e.g., Woodlife's case, Owen, 57, Holliday v. Hicks, Crow. Elise. 638, Southcote's case, for Company. Republic 83b, 84a, Southern v. Howe, Crow. Jack. 468, St. 21 Jack. I. C. 16, Section 3, Morse v. Slew, 3 Keeble, 72. As to bailiffs, see Bracht. 26b, Rea Stituat Domino, Vel Servienti, etc., YB 7 Hen. 4, 14, PL 18. 229. 229/1 Paley, Agency, C. 4, Section 1, citing Godbolt, 360. C. Further, F. N. B. 120, G. Fitz. ABR, Det, PL 3, Y. B. 8 ed. 4. 11, PL 9. These rules seem to be somewhat modern even as to servants. The liability of a master for debts contracted by his servant is very narrowly limited in the earlier yearbooks. 230. 230/1 I am inclined to think that this extension has been largely due to the influence of the Roman law. See Lecture I page 20, n. 1, and observe the part which the precedents as to fire, e.g., YB 2 Hen. 4, 18, PL. 6, have played in shaping the modern doctrine of master and servant. Tuberville v. Stamp, I limited Rame. 264, where Lord Holt's examples are from the Roman law, Brucker v. Fromont, 6t. R. 659, Manus v. Cricket, 1 East, 106, Patton v. Ray, 2 CB. NS 606. In Southern v. Howe, Popham, 143, doctor and student is referred to for the general principles of liability. Doctor and student states Roman law. See, further, Boson v. Sanford, 1 Shower, 101, 102. 230/2 back. AHR. Master and Servant, K. Smith, Master and Servant, 3D edition, 260, n. T. 230/3 Clapp v. Kemp, 122 Massachusetts 481, Murray v. Curry, LR 6 CP 24, 28, Hill v. Maury, 26 Vanuatu Vatu, 178. 230/4C, e.g., Patton v. Ray, 2 CBNS 606, Bolingbroke v. Swindon Local Board, LR 9 CP. 575. 230/5 Freeman v. Rosher, 13 Q.B.780, 785, Gauntlet v. King, 3 C. B. NS 59, Hazeler v. Lemoyne, 28 L. J. CP 103, Collett v. Foster, 2 H. and N. 356, Barwick v. English Joint Stock Bank, LR 2X 259, 265, 266, Lucas v. Mason, LR 10X. 251, 253, last paragraph, McKay v. Commercial Bank of New Brunswick, LR 5 PC 394, 411, 412. So as to Partners, 3 Kent's Com, 12th edition, 46, notes, d, and 1. 231. 231/1 Bush vs. Steinman, 1b, and p. 404, 409. 231/26 M and W 358. Cf. Udall v. Atherton, 7h, and N 172, 184, for a comment like that in the text. Other grounds for the decision are immaterial here. 231/3 McKay vs. Commercial Bank of New Brunswick, LR 5 PC 394, Barwick vs. English Joint Stock Bank, LR 2X 259. Western Bank of Scotland vs. Addy, LR 1HL, SC 145, 2 Kent, 12th edition, 616, N. 1, Swift vs. Dewsbury, LR 9Q.B.301, overruling SC sub nom. Swift vs. Winterbotham, LR 8Q.B.244, were vs. Bell, 3XD, 238, 244. The objections which Baron Bramwell mentions, LR 9QB. 815, to holding one man liable for the frauds of another, are objections to the peculiar consequences attaching to the relation of master and servant in general, and have been urged in that more general form by the same learned judge. 12 A.M. Law Rev. 197, 200, 2H and N 856, 361. C 7 A.M. Law Rev 61, 62. 231/37 A.M. Law Rev 63, October 1872. 232. 232/1D, 44. 2, 4, Note 17, Elsevier ed. 232/2 Hunter's Roman Law, 431. 232/3 Ancient History of INST 235. 232/4 CF Gillett vs. Ball, 9 Pennesty. 13, Craig vs. Gilbreth, 47 Me. 416, Nicholson vs. Knowles, 5 Maddock, 47, Williams vs. Port, LR 12 EQ 149, Adams vs. Jones, 12 Ad. And L 455, Bracton, Folios 28b, 42b, 43. And compare with the passage cited above from Blackstone, Possitor, Cujus Reomine Possiditer, Procurator Alieni Possessioni Praestat Ministerium. D. 41. 2, 18, pr. 233. 233/1 Ward vs. Macaulay, 4T, R. 489, 490. Cf. as to factors supra, p. 228. 233/2 Bernson vs. Strang, LR 3CH 588, 590. 233/3 Blackburn, Sale, 33, Marvin vs. Wallace, 6L and BL 726. 233/4D, 41. 2, 18, pr. Quod meo nomini possidio, possum alieno nomini possidir, nec enim muto mihi causam possessionis, sed desino possidir et alium possessorum ministerio meo facio. Nec idem est possidir et alieno nomini possidir, nam possidet, cujus nomini possiditur, procurator alieni possessioni praestat ministerium. Thus showing that the vendor changed possession by holding in the name of the purchaser, as his agent to possess. Cf. Bracton, Folios 28b. 233/4 Winshide, Pand. Section 155, N. 8a, 2 Kent, 12th edition, 492, N. 1a. It should be kept in mind also that the Roman law denied possession to bailies. 234. 234/1c, e.g., Farina vs. Home, 16M and W, 119, 123. 235. 235/1 McGahey v. Moore, 3 Ired. N. C. 35. 235 2 Reader vs. Moody, 3 Jones, N. C. 372, cf. Bassett vs. Maynard, Crow. Elise. 819, 820. 235 3 Brown vs. Dawson, 12A and E 624. CFD, 43. 16, 17, IB3, Section 9, D, 41. 2, 18, Section 3, Clayton, 147, PL 268. 236. 236 of 1 cf. Bruns, R. D. Besitzes, 503. 237. 237/1 Clark v. Maloney, 3 Harrington, Delaware, 68. Bruns, R. D. Besitzes, 503, 507, comes to the same conclusion on practical grounds of convenience, although he utterly repudiates it on theory. I must refer to what I said above touching these conflicts between theory and convenience. 238. 238/1 Bruns, R. D. Besitzes, Section 57, page 486. A learned writer of more ancient date asks why a doctor has not a possessory action if you cease to employ him, and answers, Sentio actionem non tenera, sed sentio tantum, necsi vel mort mineris, possum dic requere. 2 Lector, si sapes, rations decidendi sugera. Hummel, Raps, QU 489, cited, Bruns, 407. 239. 239/1 Gardner vs. Thibodeau, 14 Law and 732. 239 of 2 Bruns, 483. 240. 240/1 2 Kent, 12th edition, 205, n. 1. CFYB 21 Hen. 6, 8, 9, PL 19. American Note to Scott vs. Shepard, in 1 SM, L. C. AM. Edition. 240/2 Britain, Niche. Edition, I, 277, cf. Bracht, folios 164b, Fleta, folios 214, Glanv, lib 13. C. 37, Littleton, sections 237 to 240, 588, 589, 3 BL Com 170, 3 Cruz, Dig, Tit. 28. Rents, ch2, section 34. 241. 241 to 1 see lecture 11. 241/2 cf. Stockport Water Works vs. Potter, 3H, and C, 300, 318. The language in the 7th English edition of 1 SM, L. C, 300, is rather too broad. If the law should protect a possessor of land in the enjoyment of water coming to it, it would do so because the use of the water was regarded as a part of the enjoyment of that land. And would by no means imply that it would do the same in the case just put of away over land of another. 242. 242/1 Jeffries v. Great Western Railway Company, 5L and B1. 802, cf. Armory vs. Delamory, 1 Strange, 505, 1 SM, L. C. 242/2 Company. Lit. 145b. 242/3 2 WMS Sond. 47b, Note 1, to Wilbraham vs. Snow. 242/4 Bracht, folios 150b, 151, Supra, page 168. YB 22 ed. I, 466 to 468. 242/5 YB 48 ed. 3. 20, 11 Hen. 4, 17, 11 Hen. 4, 23, 24, 21 Hen. 7, 14. The meaning of SUA is discussed in YB 10 ed. 4. 1, b, by Catesby. Compare La Bande, Vermogensrechtlichen Klagen, 111. Huesler, Gura, 492 Eid Sikh, correcting Bruns, R. D. Besitzes, 380 Seek, Sohm, Proc. D. L. Sal, Section 6. 243. 243/1 YB 11 Hen. 4, 17, PL 39. 243/2 YB 21 Hen. 7, 14B, PL 23. 243/3 Godbolt, 173, PL 239. CF 11 Hen. 4, 17, PL 39. 243/4 Bro, ABR, Trespass, PL 433, Sit YB 13 Hen. 7, 10. 243 of 5 Keeling, 89. C. Further, Buller, N. P. 33. 243/6 Lecture V, YB 20 Hen. 7, 1, PL 11. 243/7 YB 21 Lean. 7, 14B, PL 23. 243/8 1 Roll. ABR, 4, 5, I, PL 1. CF. Arnold vs. Jefferson, 1 Lord Rame. 275. 244. 244/129 Ass, Folios 163, PL 28. 244/2 Southcote's Case, for Company. Republic 83b. 244/3 Moraes vs. Conham, Owen, 123. CF Ratcliffe vs. Davis, I Bolster. 29. 244/4 Doe vs. Diebol, Mood. And M, 346 and Note, 2 WMS. Sond. 111, and later notes, I add. And L119, Asher vs. Whitlock, LR1Q.B.1. 244/5 Graham vs. Pete, 1 East, 244. 245. 245-1 As to this period see Husler, Gura. Cf. Lavely, Propriet, 166. 248. 248/1 History du Droit Franc, pp. 146 E. Seek, 152. 248/2 Anciens Poètes de la France, Guessard, page 71. 248/3 page 283, cf 284, Xvae, E. Seek, 44, 69. 249. 249-1 Sohm, Proc. D. Lex. Sal, sections 15, 23-25, Tr. Thevenin, pages 80, 105, 122. 249 of 2 Essays in A. S. Law, p. 292. 249 of 3 Cap 8, Merkel, page 48. 249-4 Cap 89. Section 3, Essays in A. S. Law, page 291. 249 out of 5 Chapter 4. Section 16. 250. 250/1 Fitz. ABR, Main Prize, PL 12, H, 33 ed. 3. Staunford, PC 65. 250/2 ABBR, Plaque, page 343, Call 2, Rot. 37, 17 ed. 2. 250/3 Jacob, L. D. Bale. CFI Bolster. 45, Hawkins, PC, 2. Ch 15, Section 83, ABBR, Plaque, page 343, Kernel 2, Rot. 37, 17 ed. 2. 250/4 Highmore, Bale, page 199, Jacob, L. D. Bale. Cf 2 Le Ferrière, Histoire du Droit Franc, p. 148. 250/5 Highmore, page 195. 250/6 Ibid, page 200. 252. 252/1 Vermoegensrichlichen Klagen. 253. 253/12. C. 60, Section 25. Glanville's Justa Debendi Causa, lib x, c. 4, seems remote from consideration. 254. 254/1 YB3 Hen. 6, 36. 254/2 YB 37 Hen. 6, 13, PL3. 254/3 YB 37 Hen. 6, 8, PL33. 254/4 Glanv, lib x, c. 12, Bract, folios 400b, section 10, 22 as, PL70, folios 101. 255. 255/1 Essays in A. S. Law, 187. 256. 256/1 I. 45, 3. 10. 256/2 lib x e. 17. Suit, secta, was the term applied to the persons whose oath the party tendered. 257. 257/1 lib x c. 12, Beams, page 262, c. 8 and c. 5, Beams, pages 256, 251, cf 4. c. 6, where witnesses are tendered devisu et auditu. Cf. Bract. 315b, section 6 Fleta, 2. c. 63, section 10, page 137. It was no doubt true, as Glanville says, lib x c. 17, that the usual mode of proof was by a writing or by duel, and that the King's Court did not generally give protection to private agreements made anywhere except in the court of the king, lib x c. 8. But it can hardly be that debts were never established by witness in his time, in view of the continuous evidence from Bracton onwards. 257/2 But cf. Brunner, Schwergericht, 399. I do not go so far as to say that they were still a living institution. However that may be, tradition must at least have modeled itself on what had been the function of the former official body. 257/3 Bract, folios 315b, section 6, Brit. Niche. I, page 162, Magna Carta, c. 38, YB 21 ed. I, 456, 7 ed. 2. 242, 18 ed. 2. 582, 3 BL Com 295, 344. Cf 17 ed. 3. 48b. 257/4 Cf Glanv, lib 4. c. 6. 258. 258/1 lib x c. 18. It is possible that this means no more than Glanville's often repeated statement, that the King's Court did not, generally speaking, take cognizance of private agreements. The substantive law was, perhaps, still limited by traditions from the infancy of contract. See pages 248, 251, 259, 260. The proposition in its broadest form may have been based on the inability to try such agreements in any way but those which have been specified. Cf. the requirement of alium derationationem and aliis probationibus, in lib x, c. 12. But cf. Ibid. With essays in A. S. Law, pages 189, 190. 259. 259/1 Sherrington vs. Stratton, Plowden, 298, at page 302, m. 7 and 8 Elise. 259/2 Pillins vs. Van Meyerop, 3 Borough, 1663, 1669. 260. 260/11 Thorpe, ANC Laws, 181, Oaths, 7, 8. 260/2 Glanv, lib x c. 5, Beams, page 251, YB 7 ed. 2. 242, Novi Nar. Det Ver Pledge, Rastel's Law Tracts, page 253, d. 2 Final. Reeves, 376. 261. 261/1 Glanv, lib x c. 22, Beams, page 263, Bract, folios 398b, section 1. The favorite proof by duel was also allowed, but this disappeared. When the inquest became general, the execution of the deed was tried, like any other fact, by that means. 261/2 Bract, folios 315b, section 6, 400b, Coke, 2 Dinst. 44, 45. 262. 262/1 Glanv, lib x c. 12, Beams, page 263, Bract, folios 100b, section 9. 262/2 Glanv, lib x c. 17, Beams, page 272. 262/3 Bract, folios 400b, section 9. 262/4 CFYB 20 ed. I, 304, and 34 ed. 2, 150, 152, IB 330, 332, 35 ed. I. 546. 263. 263/1 Bract, folios 400b, section 8. 263/2 CFYB 20 ed. I, 304. 263/3 Cap 28, 32 and 33 ed. I, 516, 18 ed. 2. 582, Fleta, 2. C. 63, section 9, Coke, 2 Dinst. 44, 3 BL Com 344. 263/4 YB 18 ed. 2. 582, 17 ed. 3. 48b, PL. 14. 264. 264/1 YB 29 ed. 3. 25, 26, CF 48 ed. 3. 6, PL 11, Fleta, 2. C. 60, section 25, Glanville, lib x c. 12. 264/2 CF Bro. ACC, Sir Look Case, PL 5, SC, 27 Hen. 8, 24, 25, PL 3. 264/3 YB 18 ed. 3. 13, PL 7. 264/4 YB. 44 ed. 3. 21, PL 23. 264/5 FNB 122, I, in margin. CFFNB 122K, YB 43 ed. 3. 11, PL 1, SC, Bro, Pledges, PL 3, 9 Hen. V 14, PL 23. 265. 265/1 YB 17 ed. 3. 48b, PL 14. CF Fortescue, Amos, 67, N, 3 BL Com 295. 265/2 for limit, C. Constit. Of Clarendon, C. 15, Glanv, lib x, C. 8, 12, YB 22 As, PL 70, folios 101, 45 ed. 3. 24, PL 30, 19 R. 2, Fitz. ABR, Det, PL 166, 37 Hen. 6, 8, PL 18, 14 ed. 4. 6, PL 3, 15 ed. 4. 32, PL 14, 19 ed. 4. 10, PL 18, 20 ed. 4. 3, PL 17. 266. 266/1 C for an illustration 2 Kent's Com, 12th edition, 451, N, 1, B. 266/2 Repromititor, but CF pro servicio tua vel pro homaggio, Fleta, 2. C. 60, section 25. 267. 267/1YB 29 ed. 3. 25, 26. But CF 48 ed. 3. 3, PL 6. 267/219 R. 2, Fitz. ABR, Det, PL 166. 267/3YB 12 Hen. 4, 17, PL 13, Ad Fin. 267/4YB 9 Hen. V 14, PL 23. 267/5, CF 13 ed. 2. 403, 17 ed. IIL 48, PL 14, 29 ed. 3. 25, 26. 41 ed. 3. 7, PL 15. 46 ed. 3. 6, PL 16, Fitz. ABR, Det, PL 166. 267/6YB 3 Hen, 6. 36, PL 33. 268. 268/1YB 37 Hen. 6, 8, PL 18. 268/2EG, Rolf and YB 3 Hen. 6, 36, PL 23. 269. 269/1YB 37 Hen. 6, 8, PL 18. CF Bro. Fefmans al uses, PL 54, Plowden, 301. 269/2YB 15 ed. 4. 32, PL 14, SC, 14 ed. 4. 6, PL 3, Winky Face. 17 ed. 4, PL 4. 269/3 CFYB 37 Hen. 6, 8, PL 18, 17 ed. 4. 4, 5, Plowden, 305, 306. 269/4YB 3 Hen. 6, 36, PL 33. 269/5YB 37 Hen. 6, 13. 269/6 as to requirement of certain sum, CFYB 12 ed. 2. 375, Fleta, 2. C. 60, Section 24. 270. 270/1YB 29 ed. 3. 25, 26, 40 ed. 3. 24, PL 27, 43 ed. 2 1. 2, PL 5. 270/2YB 43 ed. 3. 2, PL 5, 46 ed. 3. 25, PL 10. 50 ed. 3. 5, PL 11. 270/3 CF Glanv, Lib X C 8, Fleta, 2. C. 60, Section 25. 270/4YB 35 ed. I. 454, 12 ed. 2. 375. 272. 272/1 Ducange, Sigillium, in Gulf. 901. 272/2 Big. PL Ong Norm. 177. 272/3 Big. PL Ant Norm. 177, Bract. Folios 100b, Section 9, Scriptura. But CFYB 30 ed. I. 158, Fleta, 2. C. 60, Section 25. 272/4YB 33 ed. I. 354, 356, 35 ed. I. 455, top, 41 ed. 3. 7, PL 15, 44 ed. 3. 21, PL 23. CF 39 Hen. 6, 34, PL 46. 272/5YB 7 ed. I. 242. CF 35 ed. I. 452. 272/6 CF Bract, Folios 100b, Section 9. 272/7 CF Glanv, Lib X C. 12, Dugdale, Antique, Warwick. 673, Cited Ducange, Sigelum, Bract, Folios 396b, Section 3, Ibrit. Niche, 163, Section 17, Abreve. Plaque. 8 Joe, Burke. Rot. 4, pp. 55, 56, IB 19 ed. I, North. And Surf. Rot. 7, page 284, IB Index, Sigelum. 272/8 YB 30 ed. I, 158, Fleta, 2. C. 60, Section 25, page 130. 273. 273/145 ed. 3. 24, PL 30. 273/2 Bract, Folios 100b, Section 9. 275. 275/1 CF 5 Company. Rep. 13b, 14a, with 1 roll. Republic 126, 128, YB 43 ed. 330, PL 15. 275/2 YB 46 ed. 3. 19, PL 19, SC Bro, ACC, Sir Look Case, PL 22. 275/3 YB 22 AS, PL 4I, Folios 94. 276. 276/1 YB 43 ed. 3. 33, PL 38. 277. 277/1 YB 11 Hen. 4, 33, PL 60. 277/2 YB 3 Hen. 6, 36, PL 33. 277/3 YB 2 Hen. 4, 3, PL 9, 11 Hen. 4, 33, PL 60. CF 3 Hen. 6, 36, 83. 279. 279/1 CF 19 Hen. 6, 49, PL 5 Ad Fin, Newton, C. J. 280. 280/1 CF YB 48 ed. 3. 6, PL 11. 280/2 Cases Supra, YB 2 Hen. 4, 3, PL 9, 11 Hen. 4, 33. CF 3 Hen. 6, 36, PL 33, 20 Hen. 6, 34, PL 4, 2 Hen. 7, 11, PL 9. 281. 281/1 YB 48 ed. 3. 6, PL 11. CF Fitz. ABR, ACC, Sir Look Case, PL 37, 11 R, 2, 14 Hen. 6, 18. But CF 43 ed. 3. 33, PL 38. 282. 282/1 CF Candish's Reasons for Allowing Wager of Law with YB 32 and 33 ed. I. Preface, page 36. Citing the old rules of pleading printed at the end of the tract entitled, Modus tenendi unum hundredum sire curiam de recordo, in Rastle's Law Tracts, page 410, E, F, G. 282/2 YB 3 Hen. 6, 36, PL 33. 282/3 YB 2 Hen. 4, 3, PL 9, 11 Hen. 4. 33, PL 60, 3 Hen. 6, 36, PL 33. 282/4 3 Hen. 6, 36, PL 33. 283. 283/1 YB 14 Hen. 6, 18, PL 58. 283/2 Ibid, cf 48 ed. 36, pl 11. 283/3 YB 19 Hen. 6, 49, pl 5. See, further, YB 20 Hen. 6, 25, pl 11. 284. 284/1 cf YB. 3 Hen. 6, 36, pl 33. 284/2 YB 2 Hen. 7, 11, pl 9. cf 20 Hen. 6, 34, pl 4. 284/3 cf YB 14 Hen. 6, 18, pl 58, 21 Hen. 7, 41, pl 66, Phoenix, C. J. 284/4 Keelway, 160, pl 2, 2 Hen. 8, Poutwary vs. Walton, 1 roll. ABR, 10, pl. 5, 39 Elise. Coggs vs. Bernard, 2 Lord Rame. 909, 2 N. AD 1703. Supra, page 195. 285. 285-1 Sands vs. Trevelyan, Crow. Carr. 193, 194, Michigan 4 Carr. I. AD 1629. 285/2 Bro, ACC, Sir Look Case, PL 5, SC, YB 27 Hen. 8, 24, 25, PL 3. Sydenham vs. Wellington, 2 Leon. 224, AD 1585. 285/3 YB 21 Hen. 7, 30, PL 5, IB 41, PL 66. 285/4 YB 3 Hen. 6, 36, PL 33. 286. 286/1 Sherrington vs. Stratton, Plowden, 298, Michigan 7 and 8 Elise, IB 309, note on, the civil law. 286/2 Hunt vs. Bate, 3 Dyer, 272A, 10 Elise, AD 1568. 286/3 See Lecture 8. Mr. Langdell, Contracts, Sections 92, 94, suggests the ingenious explanation for this doctrine, that it was then held that no promise could be implied in fact from the request. There may be evidence which I do not know, but the case cited, Boston v. Thin, Yelv. 40, for this statement was not decided until AD 1603, while the implication of Hunt vs. Bate, Supra, which was the authority followed by the cases to be explained, is all the other way. 286/4 Sydenham vs. Wellington, 2 Leon. 224, AD. 1585. 287. 287-1 Red vs. Baxter, 3 Dyer, 272b, N, 26 and 27 Elise. C.F. Richards and Bartlett's case, 1 Leon. 19, 26 Elise. 287/2 Bro, ACC, Sir Look Case, PL 5, SC, YB 27 Hen. 8, 24, 25, PL 3, 3 Dyer, 272, N. 287 of 3 Marsh v. Rainsford, 3 Dyer, 272b, N, SC, 2 Leon. 111, and Crow. Elise. 59, Sub. Nom. Marsh vs. Cavenford. 287/4 Smith and Smith's case, 3 Leon. 88, AD 1583, Riches and Briggs, Yelv. 4, AD 1601, Pickes vs. Guile, Yelv. 128, AD 1608. 288. 288/1 Supra, page 195. Lord Coke's caution not to rely on the abridgments is very necessary to the proper study of the history of consideration. The abridgments apply the doctrine to cases which make no mention of it, and which were decided before it was ever heard of. 290. 290/1 YB 46 ed. 3. 19, PL 19, 19 Hen. 6, 49, PL 5, Keelway, 160, PL 2, Poutwary vs. Walton, 1 roll. ABR. 10, PL 5, Coggs vs. Bernard, 2 Lord Rame. 909. 290-2 Riches and Briggs, Yelv. 4, AD 1601, Pickes vs. Guile, Yelv. 128. 291. 291/1 Bainbridge vs. Firmstone, 8 ad. And L 743, AD 1838. 291/2 Wilkinson vs. Oliveira, 1 Bing. N. C. 490, AD 1835. Hay vs. Brooks, 10 ad. And L 309, pound 323, Hart vs. Miles, for CBNS 371, AD 1858. 291/3 Wheatley vs. Lowe, Crow. Jack. 668, AD 1623. C.F. Bine and Plains case, 1 Leon. 220, 221, 32 and 33 Elise. 291/4 Wilkinson vs. Oliveira, 1 Bing. N. C. 490. Hay vs. Brooks, 10 ad. And L 309, Hart vs. Miles, for CBNS 371, 6 a.m. Law Rev 47, October 1871. 292. 292/1 Supra, pages 196, 197. See also Lecture 7. 292/2 Biles, J., in Shadwell vs. Shadwell, 30 L. J. CP 145, 149. 292/3 Shadwell v. Shadwell, Ubi Supra, Burr vs. Wilcox, 13 Allen, 269, 272, 273. 292/4 Thomas vs. Thomas, 2Q.B.851. 293. 293/1 Price vs. Jenkins, 5 CHD 619. CF Grab vs. Moxie, 1 W. R. 226, Thomas vs. Thomas, 2Q.B.851, Monahan, Method of Law, 141 Eat Seek. 294. 294/1 Ellis vs. Clark, 110 Massachusetts 389. 294/2 Fitch vs. Snedeker, 38 N. Y. 248, criticizing Williams vs. Carwardine, 4 Barn. And ad. 621, where, however, it does not appear that the plaintiff did not know of the offer of a reward, but merely that the jury found that she was in fact actuated by other motives, a finding wholly beside the mark. 296. 296/1 YB 29 ed. 3. 25, 26. 296/219 R. 2, Fitz. ABR, Det, PL 166. 296/3 Hunt vs. Bate, Dyer, 272, AD 1568. 297. 297/1 C. Barker vs. Halifax, Crow. Elise. 741, SC 3 Dyer, 272A, N. 32. 297/2 Sydenham vs. Wellington, 2 Leonard, 224, Boston vs. Thin, Yelv. 40. Lampley vs. Brathwaite, Hobart, 105, Langdale, Cass. On Contract, 2D edition, CH2, Section 11, Summary, Sections 90 et seq. See above, Lecture 7. Page 286. 297/3 Pollock, Contract, LST edition, page 6. 298. 298/1 Canham vs. Berry, 15 CB 597, 619, Jones v. Howe, 9 CB 1, 9, Com Dig. Condition, D, 2, I roll. ABR, 420, D, PL 1, YB 22 ed. 4. 26, PL 6. 301. 301-1 G vs. Lancashire and Yorkshire Railway Company, 6H, NN, 211, 218, Bramwell, B, CF Hydraulic Engineering Company v. McAfee, 4QBD. 670, 674, 676. 301/2 British Columbia Sawmill Company v. Nettleship, LR3 CP 499, 509, Wiles, J, Horn vs. Midland Railway Company, LR7 CP 583, 591, SC, LR8 CP 131. 302. 302/1 British Columbia Sawmill Company v. Nettleship, LR3 CP 499, 509. 304. 304/1 Chao vs. Kenward, 3 Deg, and J, 27. 304/2 Langdell, Contract, Sections 89, 28. 305. 305/1 Langdell, Contract, Section 57. 305/2 Ibid, Sections 14, 15. 306. 306-1 But C. Langdell, Contract, Sections 14, 15. 309. 309/1 Raffles vs. Wichelhouse, 2H, and C. 906. C.F. Kyle vs. Kavanaugh, 103 Massachusetts 356, 357. 309/2 C.F. Cocker vs. Crompton, 1B, and C. 489. 310. 310/1 Smith vs. Hughes, LR6Q.B.597. 310/2 C. Gardner vs. Lane, 12 Allen, 39, SC. 9 Allen, 492, 98 Massachusetts 517. 311. 311/1 Goddard vs. Monitor Insurance Company, 108 Massachusetts 56. 313. 313/1 C. Cundy vs. Lindsay, 3 App, Cass. 459, 469. C.F. Reg v. Middleton, LR2 CC 38, 55 Eid Seek, 62 Eid Seek, Reg v. Davies, Dearsley, CC 640, Rex v. Mucklow, 1 Moody, OC 160, Reg v. Jacobs, 12 Cox, 151. 313/2 Presentia Corporis Tollit Erorum Nominis. C.F. Biles, J., in Way vs. Hearn, 32L J. NSCP 34, 40. But cf. the conflicting opinions in Reg v. Middleton, LR2 CC 38, 45, 57. It would seem that a proper name or other identification of an object or person as specific may have the same effect as an actual identification by the senses, because it refers to such an identification, although in a less direct way. 316. 316/1 Brown vs. Foster, 113 Massachusetts 136. 316/2 Leak, Dig. Contract, 13, 14, 637, Hunt vs. Livermore, 5 Pick. 395, 397, Langd. Contract, 2D edition, Section 36. 316/3 Leak, Dig. Contract, 638, Braunstein vs. Accidental Death Insurance Company, 1B, and S. 782. 316/4 But C.F. Langd. Contract, 2D edition, Section 29. 318. 318/1 Langd. Contract, 2D edition, Section 29. 318/2 Bullen and Leak, Prec of Plead. 3D edition, 147, Conditions Precedent. 319. 319/1 CF Court v. Ambergate, Nottingham and Boston and Eastern Junction Railway Company, 17Q.B.127. 320. 320/1 Goodman v. Pocock, 15Q.B.576, 1850. 325. 325/1 Fisher v. Mellon, 103 Massachusetts, 503. 325/2 Supra, page 136. 327. 327/1 Langd. Contract, 2D edition, section 33. 328. 328/1 See the explanation of Dymek v. Corlett, 12 Mu. PC 199, in Ben v. Burness, 3B and S. 751, 760. 329. 329/1 Ben v. Burness, 3B, and S. 751. 329/2 Langd. Contract, 2D edition, section 28, page 1000. 329/3 See Lecture 8. 330. 330/1 Kennedy v. Panama, Inc. Mail Company, LR2Q.B.580, 588, Lyon v. Bertram, 20 How. 149, 153. CF Winscheid, Pand, Section 76, NN. 6, 9. 330/2 Winscheid, Pand, Section 76, 4. C. Generally, Ibid, NN. 6, 7, Section 78, pages 206, 207. Section 82, pages 216 et seq. 331. 331/1 CR, I hearing, Geist D. Roem. Rex, Section 48, 3. Page 116, Father Translate. 331/2 C, however, the language of Crompton, J, in SC, IB, and S, 877. CF Kent, Com, 12th edition, 479, N, 1, A, C. 331/3 Ben v. Burness, 3B, and S, 751, 755, 756. 334. 334/1 CF Anglo-Egyptian Navigation Company v. Rennie, LR 10 CP 271. 334/2 Ellen vs. Top, 6 Exchange 424. 335. 335/1 Contracts, 2D ed., Section 106, and Passim. 336. 336/1 Chanter vs. Hopkins, 4M. and W. 399, 404. Possibly Ben vs. Burness, stated above, might have been dealt with in this way. The ship tendered was not a ship which had been in the port of Amsterdam at the date of the contract. It was therefore not such a ship as the contract called for. 336/2 Hayworth vs. Hutchinson, LR2Q.B.447, criticized in Bench Sales, 2D edition, pages 742 et seq. 336/3 C. Thomas vs. Cadwallader, Wiles, 496, Langd. Contract, 2D edition, sections 116, 140. This is put as a case of equivalence by Mr. Langdell, Contract, section 116, but the above explanation is believed to be the true one. It will be noticed that this is hardly a true case of condition, but merely a limitation of the scope of the tenant's promise. So a covenant to serve as apprentice in a trade, which the other party covenants to teach, can only be performed if the other will teach, and must therefore be limited to that event. Cf. Ellen vs. Top, 6 Exchange 424. 337. 337/1 Langdell, Contracts, 2D edition, section 127. Cf. Roberts vs. Brett, 11 H.L. C. 337. 339. 339/1 Graves vs. Legg, 9 Exchange 709. Cf. Lang Contract, 2D edition, section 33, page 1004. Mr. Langell says that a bought note, though part of a bilateral contract, is to be treated as unilateral, and that it may be presumed that the language of the contract relied on was that of a bought note, and thus a condition in favor of the defendant. Who made it? I do not quite understand how this can be assumed when the declaration states a bilateral contract, and the question arose on demurrer to a plea, which also states that the plaintiff was by the agreement bound to declare the names. How remote the explanation is from the actual ground of decision will be seen. 341. 341/1 Recht des Besitzes, section 11, page 184, n. 1, 7th edition, ENGTR 124, n. t. 342. 342-1 INST2. Section 157. 342/2 In sui heredibus evidentius apparet continuationem dominii eo rem perjuire, ut nulla videatur hereditas fuis, quasi olim hi domini essent, ca etiam vivo pater quodamito domini existimatur. Unde etiam filius familias appellator sicut pater familias, sola nota he adiecta, per quam distinguitur genitor ab eo ca genitus sit. Etac post mortem patris non hereditatem percipere videnter, sed magis liberum bonorum administrationem consequenter hac ex causa licet non sint heredes instituti, domini sunt, nec obstat, quod licet eos ex heredere, quod eti oxidir licebat. D. 28.2, 11. Cf. Plato, Laws, Greek Characters. 343. 343/1 Lavely, Propriety, 24, 202, 205, 211, n. 1, 232, Norton, L.C. Hindu Law of Inheritance, page 193. 343/2d 50. 16, 208. 343/3d 41. 1, 34. CFD 41. 340, Bracht, Folios 8a, 44a. 343/4d 43. 24, 13, section 5. 344. 344/1 Germania, c. 20. 345. 345/1 Littleton, section 337, Company. Lit. 209, a, b, yb8 ed. 4. 5, 6, pl1, Kielway, 44a, 17 Hen. 7, Lord North vs. Butts, Dyer, 139b, 140a, Top, Overton v. Siddall, Popham, 120, 121, Boyer vs. Rivet, 3 Bolster. 317, 321, Bain vs. Cooper, 1 Dowell. P.R. Cass. N. S. 11, 14. 345/2 YB 48 ed. 3. 2, PL 4. 346. 346/1 Vermoegensrichlichen Klagen, 88, 89. 346/2 Proc. de la Lex Salica, Tr. Thevenin, p. 72 NN 1. 347. 347-1 Ethelred, 2. 9, Nut, 2. 73, Essays in Anglo-Sax Law, pages 221 etc. 347/21 Spence, EQ, 189, note, citing Hicks, Dissert. Epist, page 57. 347/3 Glanv, lib 7. C. 2, Beams, page 150. 347/4 Ibid, C. 8, Beams, p. 168. 347/5 Reg Major, Lib 2. C. 39. 348. 348/1 Fall, 61a. 348/2 Saxonsp, 2. 60, Section 2, cited in Essays in Anglo-Sax Law, page 221, Grand Cust, de Norme, c. 88. 348/3 Brit, Folios 64b, Niche. Edition 163, Fleta, Lib 2. c. 62, Section 10. Cf. Bracht, Folios 37b, Section 10. 348/4 Brachton, Folios 61a, b. Item quaero and testator legere possit actions suas? E verum est quod non, de debitis quae in vita testatoris convicta non fuerunt nisi recognita, sed hujusmodi actions competent heredibus. Cum antera convicta sint et recognita, tun sunt quasi in bonus testatoris, e competent executoribus in foro ecclesiastico. Si autem competent heredibus, ut praedictum est, in foro seculari debent terminari, quia antiquam communicantur et in foro debito, non pertinet ad executors, ut in foro ecclesiastico convincantur. 349. 349/1 Brachton, Folios 62a. 349/2 YB. 20 and 21 ed. I. 232, CFIB 312. 349/3 Oates vs. Frith, Hob. 130, CFYB 5 Hen. 7, 18, PL 12, Popham, J., in Overton vs. Siddall, Poff. 120, 121, E. 39L. Boyer vs. Rivet, 3 Bolster. 317, 319-322, Brooker's Case, Godb. 376, 380, p. 3 Carr. I. 349/4 Bain vs. Cooper, 1 Dowell. Pract. Cass. N. S. 11, 14. CFYB 14 Hen. 8, PL 5, at Folios 10. 350. 350/1 Bracht, Fall. 66b, 76b, and Passam, YB 20 ed. I. 226, 200, Littleton, Section 241. The same thing was said where there were several executors, they are only in the place of one person. YB 8 ed. 4. 5 PL 1. 350/2 Com 385. 350/3 CF Glanv, Lib 7. C. 3, F. N. B. 21 L. Dyer, 4b, 5a. 351. 351/1 CF Bracht, Folios 80b. 351/2 Carta Divis. Reg Frank, Art. 9, and 8. Cf 3 La Ferrière, Histoire du droit français, 408, 409. 351/3 Glanv, Lib 9. C. 1, Beams, pages 218, 220, Bracht, Folios 79b. 352. 352/1 Brooker's Case, Godbolt, 376, 377, PL 465. 352/2 Dyer, 1b. CF Bain vs. Cooper, 1 Dowell. PRC NS 11, 12. 354. 354/1 in the American Law Review for October, 1872, 7. 49, 50, I mentioned one or two indications of this fact. But I have since had the satisfaction of finding it worked out with such detail and learning in I Hearingsgeist der Römischen Rechts, sections 10, 48, that I cannot do better than refer to that work. Only adding that for my purposes it is not necessary to go so far as I Hearing, and that he does not seem to have been led to the conclusions which it is my object to establish. See, further, Clark, Early Roman Law, 109, 110, La Ferrière, Histoire du droit franc, I. 114 e Seek, d. 1.5. 4. Section 3, Gay Inst 4. Section 16, IB2. Section 69. 356. 356 to 1 Arbitrage, I. 15 e Seek. 356/2 Histoire du droit franc, 4. 500. 356/3 Quantum der Volurit aut totem furtionum eui volurit der, nec majus nisi quantum ei creditum est. Lex Sal. Merkel, XLVI. 356/4 Lex Sal. Merkel, Cap XLV, de ad Pfaffenmeyer, Somme, Frank. Reichs U. Gerichtsverfassung, 69. 356/6 Bestseller, Arbitrage, I. 101, 102, 105. 357. 357/1 Omnem facultatem swam, scu quicunc libet de proximus vel extraneus, adoptar in hereditatem vel in ad fatimi vel prescripturarum serem scu per traditionem. L. Rib. Cap L. Al. XLV, CFL, Thuring. 13, So Cap. Rib. Section 7, Ca filios non haburit et alier quemlabet hirdem faceris sibi volurit coram reg, traditionem faclat. 357/2 ed. Roth, Cap. 174, 157, cf. pound 369, 388, Liat per. 3, 16, Al 2, 6. 155, Al 102. Cf. Bestseller, Arbitrage, I. 108 e Seek, ESP 116 to 118. Compare the Charter of AD 713, Offero. S. P. Ecclesia quam mihi hirdem constitui. Mem. D. Luca v. B. No. 4. Troia 3. Number 394, cited Husler, Gura, 45, 46. Cf. IB 484. This, no doubt, was due to Roman influence, but it recalls what Sir Henry Maine quotes from Elphinstone's History of India, I. 126, as to sale by a member of one of the village communities, the purchaser steps exactly into his place, and takes up all his obligations. Ancient Law, ch. 8, pages 263, 264. 357/3, Merkel, Cap LVA, de Crenacruda. Somme, Frank. R. U. G. Verf. 117. 358. 358/1 AD 679, Secuti tibi donata est ir 18 edi posteritue. Kemble, Cod. Dip, I. 21, No. 16. Uhtred, AD 767, quam is semper possidit et to post secui volurit heredum relinquat. IB, I. 144, Xvexi. Quilibet heredi volurit relinquat is very common in the later charters, IBV 155, Mlexil, pound 6. 1 MCCXVL, it. 31 MCCXXX, pound 38, Mixxiv, and Passim. This may be broader than CUI volurit hieralim. Offa, AD. 779, Gut se viverite have, deet. Eti post se so propinquitatis homini cui ipsi vo, possidendum labura utens potestate relinquat. IB I 164, 165, CXXXVI. Ethelbald, AD. 736, Ita ut quamdiu vixerit potestatum habet tenendi ac possidendi quicunc volurit vel eo vivo vel cert post obitum sum relinquendi. IB I 96, LXXX, CFIB v 53, MXIV. Cuthard of Kent, AD. 805, quicunc hominum volurit in aeternam libertatem derelinquit. IB I 232, CXC. Ut habet libertatem commutandi vel donandi in vita sua et post aegis obiter tenit facultatem relinquendi quicumque volueris. IB I 233, 234, CXCI, CFIB. V. 70, Mexi. Wiglaf of Mercia, August 28, AD 831, SCU vendendum ant commutandum quicumque I hurried placurit derilia quendum. IB I 294, CCXXVI. 359. 359/1 W. Et heredibus sui, videlicet quos heredes constituit. Memorials of Hexham, Surtees SOC Pub, 1864, 2. 88. 359/2 CFYB 27 As, folios 135, PL 25. Under the Welsh laws the champion in a cause decided by combat acquired the rights of the next of kin, the next of kin being the proper champion. Leah, Superstition and Force, 3d ed., 165. CFIB 161, N. 1, IB 17. 361. 361/1d, 38. 8, 1, PR. 361/2, cum is, ca ex edicto bonorum possessionum petiit, fictois e hurried agit. Gay Inst 4. Section 34. Cf. Ulp. Fragm. 18 Section 12, d. 37, 1. 2. So the Fidei Commissarius, who was a praetorian successor, d. 41. 4, 2, Section 19, 10. 2, 24, in similitudinem hierdis consistit. November 1st. 1, Section 1. Cf. Just. Inst 2. 24, PR, and then Gaius, 2. Sections 251, 252. 361 to 3 Gay Inst. 2, Sections 102 Eg Seek. CFIB Sections 252, 35. 361/4 Gay Inst for Section 35, Similiter et bonorum emptor fictois e hurried agit. CFIB Sections 144, 145. Keller, Romish Civil Process, Section 85, 3. But cf. Scherl, Lerb. Der Inst. Section 218, page 407, 6th edition. 361/5 Paulus in D. 50. 17, 128. 362. 362/1 in re legata in accession temporis quo testator possedit, legatarius quodamito quasi heres est. D. 41. 3, 14, Section 1. 362/2d 41.1.62, 43. 3, 1, Section 6. Gay Inst 2. Section 97, Just. Inst 2. 10, Section 11. 363. 363/1, Accessions Possessionum, plain tribunter hisca in locum alierum succedent siv ex contractus siv voluntate, heredibus enam et his, ca successorum loco habenter, dater accessio testatoris. Itac si mihi vendideris servum uter accession tua. D. March 14, 44, Sections 1, 2. 363/2 ABO in cujus locum hereditate vel emption aliov quo your successi. D. 43. 19, 3, Section 2. 363/3d 50. 4, 1, Section 4. CFCIC. De off. 3, 19. 76, Gay Inst 4. Section 34. 363/4 C. 2. 3, 21, C. 6. 16, 2, CFD, 38. 8, 1, PR. 364. 364/1, in locum successus accipimus sive per universitam sive in rem sit successum. D. 43. 3. 1, Section 13. CFD 21.3.3, Section 1, D. 12.2.7 and 8 winking and laughing. 39. 2. 24, Section 1. 364/2D, 41.2. 13, Sections 1, 11. Other cases put by Oppian may stand on a different fiction. After the termination of a precarium, for instance, fingitur fundus nunquam puis possessus ab ipso detentor. Gotthofred, Note 14, ELZ. Edition. But cf. Puckta, in Weisky, R. L. Art. Besitz, page 50, N.D., February 13, 41, Section 7. 364/3 INST2. 6, Sections 12, 13. CFD 44. 3, 9. C. For a fuller statement, 11 a.m. Law Rev 644, 645. 365. 365-1 Recht de Besitzes, Section 11, 7th edition, page 184, N. 1, ENGTR 124, N. T. 365/2 Paulus, D. 8. 6, 18, Section 1. This seems to be written of a rural servitude, aqua, which was lost by mere disuse, without adverse user by the servient owner. 365/3 Hermogeneous, D. 21. 3, exe. Ray Judd, D. 44. 2, 9, Section 2, IB 28, IB 11, Sections 3, 9, D. 10. 2. 25, Section 8, D. 46. 8, 16, Section 1, Keller, Roem. Civil Proc, Section 73. C.F. Bracton, Folios 24b, Section 1 ad fin. 365/4 Rect amive uti prohibitor et interdictum ei inutile est, quia ami videtur 6 vel clam vel precario possidir, ca ab auctor meo videos possidet. Nam et pedia scribit, si 6 aut clam aut precario ab co sit usus, in cuius locum hereditate vel emption aliov quo lur successi, idem esse dicendum, cum enim successorit cas in locum earum, equum non est nos naseri hoc. Quod adversus eum non nocuit, in cuius locum successemus. D. 43. 19, 3, Section 2. The variation actor, argued for by Savigny, is condemned by Mommsen, in his edition of the Digest, it seems rightly. 365/5d. 12. 2, 7 and 8. 366. 366/1 Oppian, D. 39. 2, 24, Section 1. CFD 8. 5.7, D. 39. 2. 17, Section 3, N. 79, Elsevier edition. Paulus, D. 2. 14, 17, Section 5. 366/2 Cumcas in alii locum successorit non est equum ei nocere hoc, quod adversus eum non nocuit, in cujus locum successit. Plurumque emptoris idem causa esse debet circa potendum ac defendendum, quae feudoctoris. Ulp. D. 50. 17, 156, Sections 2, 3. Ca in ius dominium alterius succedit, your aegis uti debet. Paulus, D. 50. 17, 177. Non debio melioris condionis esse, quam octor meus, a quo ius in me transit. Paulus, D. 50. 17, 175, Section 1. Quod ipsis ca contraxerant obstat, e successoribus eatern obstabit. Ulp. D. 50. 17, 143. Nemo plus juris ad alium transferre potest, quam ipsi haberet. Ulp. D. 50. 17, 54, Bract, folios 31b, cf. Decret. Greg. Lib 2. Title 13. C. 18, de rest. Spoliat, cum spoliatori quasi succedat invidium. Bruns, R. D., Besitzes, page 179. Winscheid, Pand, section 162a, n. 10. 366/3 Novitiosi quidem possessioni ola potest accedere, sed nec vidiosa ei, cus vidiosa non est. D. 41. 2, 13, section 13. 367. 367/1 Hill vs. Ellard, 3 Soc. 279, cf. Withers v. Isom, Dyer, 70a, 70b, 71a, Gatewards case, 6 Company. Republic 59b, 60b, YB 20 in 21 ed. I 426, 205, 12 Hen. 4, 7. 368. 368/1 Doe vs. Barnard, 13 Q.B.945, 952, 953, per Kerr, Pattison, J. cf. Asher vs. Whitlock, LR 1 Q.B.1, 3, 6, 7. 368/2C, further, Sawyer vs. Kendall, 10 Cush. 241, 2 BL Com 263 Eg Seek, 3 CHPL 1119, 6th AM. Edition. 3 Kent, 444, 445, Angel, Limitations, ch 31, section 413. Of course, if a right had already been acquired before the disseisin, different considerations would apply. If the right claimed is one of those which are regarded as incident to land, as explained in the following lecture, the disseisor will have it. Jenk. Cent 12, First Cent Case 21. 370. 370/1 Ard vs. Watkin, Crow. Elise. 637, SC, IB 651. CFYB 5 Hen. 7, 18, PL 12, Dyer, 4B, N, 4. 370/2 Roe vs. Haley, 12 East, 464, 470, 1810. 371. 371/1 Boyer vs. Rivet, 3 Bolster. 317, 321. 372. 372/1 Essays in A. S. Law, 219. 372/2 Per Medium, Bracton, folios 37b, section 10 ad fin. 374. 374/1 Bract, folios 17b, cf. Fleta, 3. C. 14, section 6. 374/2c, further, Middlemore vs. Goodale, Crow. Carr. 503, Stated Infra, page 379. 374/3c also Bract, folios 380b, 381. E quat de heredibus dicitur, idem dici poderit de assignatus. E quat assignatus fieri debet warrantia per modum donationis, probator in itenere W. de Raleigh in com war. Circa finem Rocheli, e hoc maxime, si primus dominus capitalis, e primus fefator, separate homagium et servitium assignati. Cf. Fleta, 6. Section 6, Moore, 93, PL 230, Chef. Touched. 199, 200. As to the reason which led to the mention of assigns, cf. Bract, folios 20b, section 1, 1 Brit. Niche, 223, 312. 375. 375/1 I do not stop to inquire whether this was due to the statute of quia emptors, by which the assign was made to hold directly of the first grantor, or whether some other explanation must be found. Cf. Bracht, Folios 37b, c. 14, Section 6, 11, 6. C. 28, Section 4, 1 Britain, Nitch, 256, 100b. 375/2 Fleta, 3. C. 14, Section 6, Folios 197, 1 Britain, Nitch, 223, 233, 244, 255, 312, Company. Lit. 384b, YB 20 ed. I, 232, ABBR, Placet, Folios 308, 2D Colonel, Dunelm, Rot. 43, YB 14 Hen. 4, 5, 6. 377. 377/1 Fall 67a, CF 54a. 377/2 Fall, 381, Supra, page 874, n. 3. 378. 378/1 CF Pincombe vs. Rudge, Hobart, 3, Bro, Waranchakart, PL 8, SC, YB 2 Hen. 4, 14, PL 5. 378/2 YB 50 ed. 3. 12b and 13. 378/3 YB 42 ed. 3. 3, PL 14, per Belknap, Arguendo. 378/4 Noak vs. Otter, Crow. Elise. 373, SC, IB 436. CF Lewis vs. Campbell, 8 Taunt. 715, SC, 3J B. Moore, 35. 379. 379/1 Middlemore vs. Goodale, Crow. Carr. 503, SC, IB. 505, Sir William Jones, 406. 379/2 Harper vs. Bird, T. Jones, 102, Pasch. 30 Carr. 2. These cases show an order of development parallel to the history of the assignment of other contracts not negotiable. 380. 380/1 Andrew vs. Pierce, for Boss. And Poole. 158, 1805. 383. 383/1 Austin, Jurisprudence, 2. Page 842, 3D edition. 383/2 Quoniam non personi, sed predia deberant, nicid query libertas nic remedi servitus per partem poterit. D. 8. 334, PR. 383/3 Ca fundum alienum bona fide mit, idenir quat ei fundo debetur usus est, retiniter id ius itineris, ac idiom, si precario aut 6 diecto domino possidet, fundus enim qualiter se habens ida, cum in sua habitu possessus est. Ius non depert, nec refert, just nec possidit cat talum eum possidet. D. 8. 6, 12. 383/4 Elsevier edition, N. 51, Adloc Cit, Cicero de L. Agr. 3, 2. 9. 383/5 D. 50. 16, 86. Cf. Ulpian, D. 41. 1, 20, Section 1, D. 8. 3, 23, Section 2. 383/6 INST 2. 3, Section 1. 384. 384/1 D. 8. 1, 14, PR CF Elsevier edition, N. 58, E. Sic Jura, Accessions Ease Possum Corporum. 384/2 Cum Fundus Fundo Servit. D. 8. 4, 12. CFD 8. 5, 20, Section 1, D. 41. 1, 20, Section 1. 384/3 Jurisprudence, 2. Page 847, 3D edition. 384/4 cf. Winscheid, Pand, Section 57, n. 10, 4th edition, page 150. 385. 385/1 Fall, 10b, Section 3. 385/2 Fall, 220b, Section 1. 386. 386/1 Fall, 221. 386/2 Fall, 219a, b. 386/3 Fall, 102a, b. 386/4 Fall, 226b, Section 13. All these passages assume that a right has been acquired and inheres in the land. 387. 387/1 Fall, 53a, cf 59b, ad fin, 242b. 387/2 Nihil prescribitor nisi quod possidetur, cited from Hale de Jure. Maris, page 32, in Blundell v. Catterall, 5b, and Alderman 268, 277. 388. 388/1 Bracht, folios 46b, cf 17b, 18, 47b, 48. 388/2 Fall, 81, 81b, 79b, 80b. 388/3 Fall, 24b, 26, 35b, 86, 208b, and CFF N.B. 123, E. Laveley, Propriet, 67, 68, 116. 388/4 ABBR, Plaque. 110, Rot. 22, Devon. Hen. 3. 388/5 Stockwell v. Hunter, 11 Met. Massachusetts, 448. 389. 389/1 Keelway, 130b, PL 104. 389-2 Keelway, 113a, PL 45, Dyer, 2b. 389/3 Keelway, 113a, PL 45. CFYB 33-35 ed. I, 70, 45 ed. 3. 11, 12. 389/4 Lit. Section 589. 389/5 Keelway, 2a, PL 2 ad fin. 12 Hen. 7, but CFYB 6 Hen. 7, 14, PL 2 ad fin. 389/6 La Ferrière, Histoire du Droit. Frank. 442, Bracton, folios 53a. 390. 390/1 CF Company. Lit. 322b, each Seek, YB 6 Hen. 7, 14, PL. 2 ad fin. 390/2 Daintree vs. Brocklehurst, 3 Exchange 207. 390/3 YB 5 Hen. 7, 18, PL 12. 391. 391/1 YB 9 Hen. 6, 16, PL 7. 391/2 YB 14 Hen. 6, 26, PL 77. 391/3 YB 5 Hen. 7, 18, PL 12. 391/4 CF Thelool, Dig. I, C, 21, PL 9. 391/5 Buskin vs. Edmonds, Crow. Elise. 636. 391/6 Harper vs. Bird, T. Jones, 102, 30 Car. 2. 391/7 Bowles vs. Nysom, Dyer, 254b, Porter vs. Swetnam, Style, 406, SC, IB 431. 391/83 BL Com 231, 232. 392. 392/1 Yielding vs. Fay, Crow. Elise. 569. 392-2 Pakenham's case, YB 42 ed. 3. 3, PL 14, Prior of Woburn's case, 22 Hen. 6, 46, PL 36, Williams's case, 5 Company. Republic 72b, 73a, Slipper vs. Mason, Nelson's Lutwich, 43, 45, top. 392/3FNB, 127, Nowell vs. Smith, Crow. Elise. 709. Starr vs. Rooksby, 1 Sock. 335, 336, Lawrence vs. Jenkins, LR 8Q.B.274. 392/4 Dyer, 24A, PL 149, FN, B 180N. 393. 393/1 FN B 128D, E, Company. Lit. 96b. It is assumed that, when an obligation is spoken of as falling upon the land, it is understood to be only a figure of speech. Of course, rights and obligations are confined to human beings. 393/2 Keelway, 145b, 146, PL 15. Sir Henry Neville's case, Ploughed. 377, 381, Chudley's case, 1 Company. Republic 119b, 122b. 393/3F B 180N, Company. Lit. 385a, Spencer's case, 5 Company. Republic 16a, 17b, Pakenham's case, YB 42 ed. 3. 3, PL 14, Keelway, 145b, 146, PL 15. Comyns's Digest, Covenant, B, 3. 394. 394/1 Holmes vs. Seller, 3 Leviticus 305, Rowbottom vs. Wilson, 8 HL.C. 348, Bronson vs. Coffin, 108 Massachusetts 175, 180. CF Bro, Covenant, PL 2. 394/2 YB 21 ed. 3. 2, PL 5, FN, B 180N. 394/3 The action is case in the Prior of Woburn's case, YB 22 Hen. 6, 46, PL 36. In FN, B 128E, N. A, it is said that a curia claudenda only lay upon a prescriptive right, and that if the duty to fence was by indenture the plaintiff was put to his writ of covenant. But see below, pages 396, 400. 394/4 YB 32 and 33 ed. I, 430. 395. 395/1 YB 20 ed. I, 360. 395/2 YB 32 and 33 ed. I, 516. 395/3 Kia Residential cum hominy, obviously a misprint for honora, transit ad quem cunc. Fall, 382, 382b. 395/4 lib 6. C. 23, section 17. 395 out of 5 Pakenham's case, YB 42 ed. 3. 3, PL 14. 395/6 Sugged. V. and P, 14th edition, 587, Rawl, Covenants for Title, 4th edition, page 314. Cf. Vivian vs. Arthur, 1b, and C. 410, Sharp vs. Waterhouse, 7L and BL 816, 823. 396. 396/1 Company. Lit. 385a. 396/2 CF Finchden as to rent in Y, B, 45 ed. 3. 11, 12. 396/3 cf. YB 50 ed. 3. 12, 13, PL2. 397. 397/1 Covenant, PL 17. 397/2 There is a colon here in both editions of the year books, marking the beginning of a new argument. 397/3 Pakenham's case, YB 42 ed. 3. 3, PL 14. 398. 398/1 Bro. Covenant, PL 5. C.F. Spencer's case, 5 Company. Republic 16a, 17b, 18a. 398/2 Horn's case, YB 2 Hen. 4, 6, PL 25. 399. 399/1 Quat Conceditor. C.F. Spencer's case, 5 Company. Republic 16a, 18a. 399/2 It was quite possible that two liabilities should exist side by side. Bro, Covenant, PL 32, Brett vs. Cumberland, Crow. Jack. 521, 523. 399/3 Company. Republic 122b, SC, Sub Nom. Dillon vs. Frayne, Popham, 70, 71. 400. 400 of 1 Essays in Anglo-Sax Law, 248. 400/2 YB 22 ed. I, 494, 496. 400/3 YB 4 ed. 3. 57, PL 71, SC, 7 ed. 3. 65, PL 67. 401. 401/1 Bracht, Folio 17b, 37b, Fleta, 3. C. 14, Section 6, 1 Britain, Niche, 223, 233, 244, 255, 312, Abreve. Plaque. P. 308, Call 2, Dunholm, Rot. 43, 33i. Y. B. 20 ed. I. 232, Company. Lit. 384b. 401/2 Hyde vs. Dean of Windsor, Crow. Elise. 552. 401/3 Spencer's case, 5 Company. Republic 16a, C.F. Minchell vs. Oakes, 2H, NN, 793, 807. 402. 402/1 Hyde vs. Dean of Windsor, Crow. Elise. 552, 553, SC, IB 457. C.F. Bally vs. Wells, 3 Wilson, 25, 29. 402/2 Dean of Windsor's case, 5 Company. Republic 24a, SC, Moore, 399. C.F. Bro, Covenant, PL 32. C.F. Further, Conan vs. Camise, W. Jones, 245, 7 Car. I. 403. 403/1 F. N. B. 181 N. Sir Henry Neville's case, Plowden, 377, 381. 403/2 Ure vs. Strickland, Crow. Jack. 240, C.F. Brett vs. Cumberland, 1 Roll R. 359, 360, Al Cummon Lay, SC, Crow. Jack. 399, 521. 403/3 Coxon vs. Cock, Crow. Jack. 125. 403/4 Sale vs. Kitchingham, 10 Hod. 158, E. 12 N. 403/5 Supra, pages 396, 398, 400. Cf., however, Lord Wensleydale, in Rowbottom vs. Wilson, 8 H. L. C. 348, 362, and see above, page 391, as to rents. 404. 404/14 Kent, 12th edition, 480, n. 1. 404/2 It is used in a somewhat different sense, is describing the relation between a tenant for life or years and a reversioner. Privity between them follows as an accidental consequence of their being as one tenant, and sustaining a single persona between them. 406. 406/1 Rowbottom vs. Wilson, 8 HL c. 348, 362, Lord Wensleydale. 406/2 Harbage vs. Warwick, 3 Exchange. 552, 556. 406/3 Rowbottom vs. Wilson, 8L and BL 123, 143, 144. 404/45 Company. Republic 16, A. 407. 407/1 YB 8 ed. 4. 5, 6, PL 1, 22 ed. 4. 6, PL 18. CF 5 ed. 4. 7, PL 16. 407/2 CF Keelway, 42B, 46B, 2 BL Com 329. 408. 408/1 YB. 14 Hen. 8, 6, PL 5. CF Chudley's Case, 1 Company. Republic 120A, 122B, SC, Nam. Dillon vs. Frayne, Popham, 70-72. 408/2 Lewin, Trusts, CHI, 7th edition, pages 16, 15. 408/34 Anst 85, Gilb. Uses, Sugged, 429, n. 6, Lewin, Trusts, 7th edition, pp. 15, 228. 408/4 Burgess vs. Wheat, 1 Eden, 177, 203, 246. 408/5 Lewin, Trusts, Introd. 7th edition, page 3. 408/61 Rich. 3 C. 1. CF Rex vs. Holland, Elaine, 14, Maynard's Arg, Bro, Fefmans Al Uses, PL 44, Gilb. Uses, 26, Sugged. Edition, 50. 409. 409/1/4 Anst 85, SC, Dyer, 869, PL 50, Jenk. Cent 6, C. 30. CF Gilb. Uses, 198, Sugged. Edition 399. 409/2 Gilb. Uses, 35, Sugged. Edition 70. 409/3 Theloals Dig, I, 16, PL 1.